Excellences,
Excellencies, President of the International Criminal Court, representative of the prosecutor, ambassador from Senegal, Mr. Registrar, Excellencies, I declare open this seventh session meeting of the 21st session of the ASP, which is entitled Handling New Challenges Going Forward on Cooperation. I just wanted to hark back to a decision that was made at the 11th session and remind everybody that this was always going to be included on the agenda of the body. This was decision ASP 11 resolution 5. And the states parties wanted to underscore on an annual basis how to support the court in using cooperation mechanisms in order to support the court's work. And so I'm delighted to open this plenary session with my dear colleagues. And now I should like to hand over to the two co-facilitators for cooperation, the ambassadors of France and Senegal, who are going to set the framework for this session, which is on cooperation. It's something that's so important for the court's success. Thank you very much, Madam President, for opening this session. Ministers, President of the Assembly, President of the Court, Prosecutor, Deputy Prosecutor, dear ambassadors, ladies and gentlemen, dear colleagues. First of all, allow me, in my own capacity, but also in the capacity of my colleague, Excellency Ambassador of Senegal, Momar Gueye, to welcome you all to this plenary session on cooperation here at the 21st session of the ASP to the Rome Statute. And allow me also, since it's the first time I'm taking part in this particular exercise, just to say how impressed and delighted I am to sit here as a co-facilitator and just here among ourselves. I just wanted to say how very determined we are to continue with this co-facilitation that Senegal and France have the honor of doing and have done for the last 6 years. We shall be continuing in our responsibility of mobilizing states to encourage them to cooperate even further with the International Criminal Court, as all of us are collectively undertaking that very commitment when we sign the Rome Statute, as we did 25 years ago, very soon. As Madam President was saying, there'll be two segments to this morning's session. I'll be moderating the very first segment, talking mostly about voluntary cooperation, and the second segment will be facilitated by my colleague, Momar Gueye, and that'll be focused on the most important issue of witness protection, which really does require cooperation from states. So the first session of this morning's plenary, as I said, will be dedicated to statements by the high representatives of the court, and I thank them very much for honoring us with their presidents, Mr. Hofmansky, and then Deputy Prosecutor, Madam Mandiye Nyang, and Silvia Fernandez del Gormende, President of the ASP, and the Registrar Peter Lewis. I wanted to say how much focus there has been on the particular voluntary agreements, and we will be able to actually witness the signing of an agreement between Spain and the ICC on sentence enforcement. Since I'm here with you, Madam President of the ASP, I'm sure that you will be able to enlighten our discussions, and I hand over to you. Thank you. Thank you very much, Mr. Ambassador. I first of all want to thank the co-facilitators for having invited me to look together at how to strengthen and promote collectively cooperation with the International Criminal Court and also cooperation between states. The ICC just simply cannot function without cooperation, because the court relies on its member states, or its states parties, I should say, as a pillar of its mandate. The states therefore have a responsibility to support the judicial functions of the ICC and offer concrete cooperation at every stage of the court's activities. States parties need to be able to set up legislation, procedures and structures that are effective and which will enable and facilitate cooperation with the court. Adopting legislation concerning the rollout or the creation of national focal points is vital for cooperation requests to be handled in alignment with national procedures and to be fulfilled effectively. In ratifying the Accord on Privileges and Immunities with the ICC, states parties are also actually contributing to safeguarding the judicial process in its entirety and guarantee the inviolability of staff and goods and communications of the court. Excellencies, distinguished participants, over and above the obligations issuing from the statute itself, there are other forms of voluntary cooperation, such as witness resettlement agreements, which we'll be dealing with in the second part of this morning's proceedings, on sentence enforcement, on hosting people who've been acquitted, suspects, or accused persons who are in provisional release. And all these different forms of cooperation are not actually strict obligations per se under the Rome Statute, but they're vital for the ICC to be able to fulfill its roles. And I'm delighted to see that this morning we're going to be able to witness the signing of an agreement on sentence enforcement between the court and the Kingdom of Spain. Signing accords like this one, I think, really does illustrate states parties' commitment to ensuring that the court can fulfill its mandate and sharing responsibility for sentence enforcement, such as imprisonment, as handed out by the court. And in this regard, the commemoration of the 25th anniversary of the signing of the Rome Statute, which will be held in early July next year in New York, 2023, will actually also have a ceremony designed to encourage states to ratify the Rome Statute and its amendments, as well as the Accord on Privileges, and to sign voluntary cooperation agreements with the court. I encourage both civil society and states parties to promote these events and to organize their own commemorative activities at the national, regional, or international levels. I just wanted to wrap up by thanking again the co-facilitators once again for their outstanding work and for having organized this plenary session. Thank you very much.
Je vous remercie.
Thank you very much, Madam President. And now I should like to hand over to the President of the Court, Mr. Hofmanski. You have the floor.
Mr. Chair, thank you very much. Excellencies, distinguished delegates, ladies and gentlemen, it's indeed a great pleasure to address this plenary meeting on cooperation, and I thank the co-chairs for inviting me to speak. Cooperation lies at the heart of the Rome Statute system, and it's vitally important for the court's functioning. As a member of the presidency, one of the areas of cooperation close to my heart is the enforcement of sentences. Although this is a form of voluntary cooperation, it remains integral to the credibility of the court. The preamble of the Rome Statute resolves to guarantee lasting respect for and the enforcement of international justice. Enforcement of sentences of imprisonment is a key part of this enforcement of international justice itself. The court does not have a prison of its own, and the sentences of imprisonment it pronounces cannot be enforced without the cooperation of a state willing to receive the convicted person. As the court's caseload increases, so does the need for voluntary cooperation in the form of enforcement of sentences. This is done by negotiating and concluding a framework agreement with the ICC, which consolidates in one document all the legal provisions to which state parties have already agreed governing the enforcement of sentences. A state may also attach conditions to the willingness to enforce sentences, which the presidency can accept or not, depending on their compatibility with the Rome Statute. I would like to stress that the conclusion of a framework agreement does not yet bind a state party to accept any sentenced person. This is because designating the state of enforcement operates on the principle of double consent. State must first agree to accept prisoners in general by concluding a framework agreement, and then again agree to accept the person convicted by the court in a specific case. Until today, 14 state parties concluded framework agreements with the court on the enforcement of sentences. Today, one more agreement will be concluded. Indeed, I am very grateful that the Kingdom of Spain has decided to join our enforcement family today by signing a framework agreement with the court. At the same time, I invite more states parties to follow suit. It is a tangible way to show support to the ICC. I note in particular that the court can have sentenced persons from all regions of the world. The court can benefit if sentenced persons are able to serve their sentences in place which are appropriate in view of their language, cultural background, and the need to maintain family ties. A broader range of states which have indicated their willingness to accept sentenced persons can only facilitate the court's capacity to achieve this. Excellencies, ladies and gentlemen, before I finish, I would like to bring to your attention another important matter, the ratification of the agreement of the privileges and immunities and the national implementation of the Rome Statute to provide national procedures for cooperation. These crucial steps should be taken by all state parties to the Rome Statute. However, almost half of them are yet to do one or the other or both. Accordingly, I urge renewed attention of these important issues, which have a real impact on the court's operational efficiency. Excellencies, ladies and gentlemen, I would like to finish my remarks with an expression of gratitude to France and Senegal for all their efforts as focal points on cooperation. I also reiterate the court's gratitude for all state parties and organizations that extend their cooperation as well as crucial political support for the ICC. Thank you very much for your attention.
Thank you very much, Mr. President, for your statement. Now I should like to hand over to the Deputy Prosecutor of the ICC, Mame Mindani Young. Thank you very much, Madam President of the ASP, my dear President of the Court, Mr. Registrar, Excellencies, ambassadors, distinguished delegates, heads of delegation, on behalf of the prosecutor Karim Khan, I should like to start by just renewing all of our thanks to His Excellency Ambassador François Alabrune and Ambassador Momar Gueye and their respective teams for all of the efforts undertaken by France and Senegal to continue working over all these years as co-facilitators on cooperation. This plenary session is yet another embodiment of this extremely important work. Excellencies, over this year, you, as co-facilitators, have never ceased in your efforts to deal delicately and effectively with major issues such as arrests, financial investigations, protecting witnesses, and other very, very important issues for the court. The message that I wanted to extend today is actually an appeal launched by the prosecutor to keep working on these collectively on working towards these stated objectives under the Rome Statute so as to improve our impact in the struggle against impunity of the most heinous crimes. And over the year, the OTP has benefited from generally a very good level of cooperation, and I just wanted to highlight the annual report of the court on cooperation, and I wanted in particular, Madam President, to reiterate our gratitude for those with the sentence enforcement agreements, which are of such importance because we don't have our own detention centres, and nor do we have a gendarmerie that's going to enable us to do things independently. So we really do depend on the states parties to assist us, and we're only really able to rely on states parties if we have these prior agreements on cooperation from states. And cooperation of states parties, but also sometimes we've had cooperation from states that are not a party to the Rome Statute, and this has enabled us to keep moving forward in our investigations. And I wanted to extend a particular thanks and pay particular tribute to those, because we're really hoping that this will stand as an example. We're really hoping that the 123 will just become bigger and bigger over a time. And every chance we do have an opportunity to do this, we want to take the opportunity. I just wanted to pay tribute to each and every one of you who have signed these upstream cooperation agreements. It can sometimes be through formal agreements. Sometimes, as I said, it can just by an MOU, which can also be very effective. And there are other forms of agreement which might not be of a very formal nature, but which enable us to access the territory, for example. You might think this is something so basic, but sometimes it actually makes all the difference, having access onto the territory. And then even if you do get access to the territory, then you have to be able to speak with the individuals. And sometimes that requires a prior authorization. And it all depends on domestic legislation. And so here again, this all comes down to cooperation on the part of states. And sometimes we don't actually need to have a specific agreement in order to undertake our investigation, but we need to get out and talk with people. And so we do need to have a cooperation, not only under an agreement on privileges, but even just simple things like having a visa, getting over difficulties that could be raised if we haven't been in touch prior with the Ministry of the Interior, for example. So I just wanted, on behalf of the OTP, to pay tribute to all of those different forms of cooperation. That's what I wanted to say this morning. Thank you very much.
Je vous remercie, Monsieur le procureur.
Thank you very much to the Deputy Prosecutor, and I'd also like to have you pass on our thanks. Thank you for all that very specific information. Thank you. Now, Peter Lewis, you have the floor.
Thank you very much to the co-facilitators for inviting me here today, and Your Excellencies, distinguished delegates, ladies and gentlemen. I'm very pleased to have this opportunity to talk to you about the new challenges we're facing on cooperation and the help we need from you. But first, before I do that, I want to pay tribute to the enormous help and cooperation we're receiving now. And first and foremost, can I add my thanks to those of my colleagues, to the two co-facilitators. They have led our efforts on cooperation for 6 long years. They've been tireless, they've been fantastic leaders, supporters, and have provided us with great encouragement through some difficult times. We all at the court owe them an enormous debt of gratitude. I must also place on record my thanks to the host state. It is not something that is often seen, but there is an enormous amount of cooperation that goes on behind the scenes to facilitate cases at court, to bring witnesses in particular to the court. And we also receive a tremendous amount of assistance from you all, both in the situation countries and more generally. In the last 12 months, the registry alone has made more than 324 requests for assistance that you've been helping us with. And to be clear, without that assistance, without that cooperation, we would not be running the trials we're running now. It's as simple as that. We need your help in a very practical way. And we also have a great deal of help from the United Nations. And again, I want to pay tribute to them. There are some places in the world where we simply would not be able to operate, and therefore no trials, without their active support for us. But as my colleagues have said, the challenges that we now face are greater than ever, simply because of the volume of work, that we're in new situations, new countries. That means new languages, it means new partnerships have to be formed, but there are also now security challenges that we haven't faced before. The court is used to operating in challenging environments, but now some of those environments are particularly challenging. In one of them, of course, where there's an active war zone. So we need now to establish new modes of cooperation that are fit for the cases and the challenges we now face. Our objective in the registry is that when we face these challenges, the court will need to be ready in real time, without delays and without hiccups. And we can only do that with your cooperation. And I just want to illustrate the scale of the challenges by talking about three particular issues, which is arrest operations, protection of witnesses, and cooperation in support of the defence. Now, on arrest, since 2018, we've had 7 successful arrest operations. But those arrest operations do not happen by accident. They happen because we have long-term strategies in place and we have cooperation ready for when an opportunity to arrest presents itself. Now, as we move to new situations and new countries and new continents, we will need to build those long-term strategies. And we will in particular need your help in terms of security, to make sure we can get people, if we do arrest people, we can get them safely back to the court in ways that we will not be able to do as we've done elsewhere by using commercial aircraft, for example. But crucially, we will need your intelligence. As the President has said, and the Deputy Prosecutor has said, we do not have many of the facilities you have, but we do not have the intelligence that you possess. And for the warrants in new situations, we will need your help and support so that we can build those detailed strategies for the future. Now, in respect of witness protection, we now have 24 agreements in place, and I was absolutely delighted on Friday to sign the 24th agreement with the Czech Republic. As I explained to them then, each one of these agreements is a precious gift to the court, and we're enormously grateful to you all for supporting us. Now, this year, 2022, you were able to help us by finding permanent places for 13 witnesses and their families. 13 witnesses and their families. However, and this was a good year for us. However, we have 21 witnesses and their families who we didn't find a permanent home for. So we're moving them from country to country. We need your urgent help to deal with this, and we're really grateful that the co-facilitators have arranged this session and the second segment, which is particularly on witness protection. And we absolutely now need your help to address the difficult issue of what we do with insider witnesses. Many of the cases the prosecutor will bring are simply not provable without the vital evidence given by insiders, and we need to find a way to protect them. The rights of the defence are also hugely important to this court, as the President has said, in so many ways, for its credibility and its integrity, but for it to function too. And we have had examples where we have discovered we haven't got the voluntary cooperation in place that we need. I'll mention interim and permanent release. There are situations, inevitably, when a person finishes their jail term and needs to find somewhere to live, and sometimes during judicial proceedings, a person quite properly will be given interim release while the proceedings are concluded. We simply haven't got enough of these agreements in place, and this is very practical. You will be aware that there was a case in 2019 at the court where 2 defendants were acquitted. In respect of one of them, we were able to quickly find a solution for them, a place where they could go, and so eventually their return to their home country could be arranged. And that's because we had an agreement on interim release with Belgium, but we didn't have enough of these agreements. So we only managed to bring about the release and return of the second individual after 3 years, and at considerable expense to you. It's your money we're spending to do these things. We've just produced a new set of voluntary agreements on interim and permanent release, and we'll be sending them to you, and I hope you'll consider them. As you're aware as well, because you've heard from me many times, we need to provide family visits for those in detention. This is not simply a matter of the rights of the individuals and their families, but it is, as I've explained, essential to running a secure, safe and functioning detention centre. Now, I'm delighted to report that we've had significant donations this year from Germany, Ireland and Austria. We need to get more, but significant donations. And you've also helped us with an ASP resolution to give us some flexibility in finding that funding in emergencies from within the budget of the registry. We will have sent to you before this session some brochures about that fund. I would ask you, please, to consider that for the future. Now, in summary, in order to meet these new challenges we face, we need your help even more than we have so far. We need help on arrests for the new situations in particular. We need support to help us affect those arrests, and also for our operations in these more demanding situations in the field. We need more relocation agreements for witnesses, and we need you to enter into these agreements for us on these other issues like interim release and the Trust Fund for Family Visits. Now, I know we can make all this happen because we've managed to produce a cooperation regime that has enabled the court to function so far. We have excellent staff at the court, in the OTP and in the registry. They do amazing work. They're hugely competent and also courageous people. But we also need your help and support now to expand the network. Thank you, Your Excellencies.
Je vous remercie.
Thank you very much, Registrar, for your statement. And I would like to take this opportunity, since this is your last participation in your capacity as the Registrar to the Assembly of States Parties, let me express to you, in my own behalf, on I believe everybody's behalf, my deepest gratitude for the outstanding job that you've done to the court, your contributions to its functioning. And so from the bottom of my heart, thank you very much. And I'd also just like to add that I had the good fortune since I arrived here to meet several people who work in your staff on issues of cooperation, as well as those working in the OTP who are in the same area. And I've always been deeply impressed by the quality of their work. Thank you. We shall now hear from the representatives of the states parties. Before giving the floor to the first speaker on the list, I would like to just say the following. As far as France is concerned, France last year signed an agreement on the enforcement of sentences similar to the one that Spain is going to be signing later on today. As it turns out, the bill in Parliament that would authorize the entry into force of this agreement is being considered today in the French National Parliament. Afterwards, it shall be forwarded to the Senate, and we anticipate it will enter into force sometime next spring. Without further ado, I shall now give the floor to the representative of Colombia. I think it's Julian Silva, the Counselor Minister at the Embassy of Colombia. Sir, you have the floor. Thank you very much. Firstly, I would like to express the ambassadors, the co-facilitators who have invited us to this. They've named us members of the working group on cooperation, and I'd like to report to you on what we've been doing over the past few months. As you know, on the 28th of October, the prosecutor announced in Bogota his decision to actually put an end to the investigation of the situation in the country for 17 years. And the reasons why this was done was because it was deemed that the national institutions had managed to address these situations of international crimes. All of this was done within the framework of the Rome Statute and with the invaluable guidance of the ICC. Just a few days ago, our Minister of Foreign Affairs spoke before this very assembly and said that during the negotiations, he was actually traveling with the agreement under his arm in his briefcase in order to work with all those stakeholders to work on transitional justice, something that was going to be very challenging for acts of violence that have been committed in over nearly 60 years. We managed to come up with a holistic system for justice and reparations and truth, and this is a process that's moving on. Now, the closing of the preliminary examination obviously acknowledges the progress that we've made in our national standards and all of the improvements we've made in our legal and judicial system, including the special judiciary jurisdiction for peace. Now, what we have in our hands is something that isn't a final product. Rather, it's a living process, something that we're going to continue building in order to meet the expectations of the international community, national institutions, social organizations, and mainly the victims themselves have placed in the system. And this is why we decided to negotiate and then sign a cooperation agreement in order to set forth a roadmap going forward, as was originally mentioned by our Attorney General in 2004. Now, once this is signed, we will be pursuing two objectives, and I would like to share them with you today. Firstly, we recognize that our system is not an endpoint. Rather, it's a vehicle that should stay in motion in order to achieve all of the objectives that come before it. My minister said that this is something that is like a tapestry that's being woven, and that as we move forward, we will continue bringing in new threads in order to make sure that everything rolls forward smoothly. And the Colombian government is committed to providing the requisite resources so that these three jurisdictions in our country, the normal ones and the special jurisdiction for peace, will be able to fulfill their mandates. And the criminal courts are also opening up new avenues to learn from past experiences, exchange best practices, and so that everybody can improve across the board. We also would like to point to the progress that we've made in our national justice system, and we can point to it as something that other countries might wish to model or at least analyze. The agreement actually gives us an alternative path to work in cooperation modalities. And so this gives us an alternative so that the court can have a constructive in relationship with those states whose jurisdictions are still deploying genuine efforts to deliver justice in complex situations. And just one last thing that I'd like to say that relates to this agreement. It's quite clear that the ICC is not giving up on its jurisdiction in Colombia. And if these general efforts to deliver justice that doesn't mean that could always be a subsequent preliminary examination to examine the situation in my country. But it's my understanding that the ICC has been squarely within its mandate, doing a professional job, and now we've managed to come up with an alternative to achieving justice. Thank you very much for giving us the floor, and we are here for anybody who's interested in getting more information about our experience. Thank you.
Je vous remercie.
Thank you, and thank you for sharing your experience with us. I think that this gives us a clear illustration of we can sign new types of agreements that can actually straddle other main principles in the Rome Statute, for example, that of complementarity in this instance. And now, it's my pleasure to give the floor to the delegation of the United Kingdom, Madam Hutchison, legal advisor for the Foreign Commonwealth and Development Office. 5 minutes, you have the floor.
Thank you, Ambassador, for giving me the floor. The Court relies on the cooperation of states parties to carry out its mandate in full. It has no police force, it has no prisons, and it cannot protect witnesses beyond a certain point. For the Court to deliver its mandate, these functions need to be provided, as the work of the Court does not end when a trial finishes. States parties have a responsibility to support the ICC's judicial and prosecutorial functions by providing concrete cooperation at all stages of the Court's activities. It is the oil that keeps the Court's engine running, including the arrest and transfer of suspects, access to evidence and witnesses, protection of individuals, and the enforcement of judicial decisions and sentences. The engine will seize without this cooperation. As a strong supporter of the Court, the United Kingdom has been pleased to assist in this regard. In 2004, the United Kingdom entered into a cooperation agreement with the Court on the protection of witnesses. Since then, we have implemented a multi-agency approach to ensure that such requests are dealt with promptly. The same goes for requests for assistance, which are dealt with by our central authority. Whether it be witness statements, requests for interviews or information, the Court has a central point of contact, leading to swifter resolution of the requests. All involved agencies and government departments, including our police war crimes team, meet regularly with the appropriate organs of the court to discuss any issues arising and to fine-tune the process. This has allowed us to provide real practical support to the court in relation to a number of investigations and preliminary examinations without delay. In 2007, the United Kingdom also entered into an agreement with the ICC regarding the enforcement of sentences imposed by the court. The United Kingdom has a strong track record of housing prisoners from international tribunals, whether for Sierra Leone or the former Yugoslavia, as well as the ICC. We will consider seriously all further requests for the enforcement of sentences of imprisonment. But we and a limited number of other states cannot do this alone. Article 103 of the Rome Statute provides that states parties should share the responsibility for enforcing sentences of imprisonment in accordance with the principle of equitable distribution as provided for in the Rules of Procedure and Evidence. A wider pool of states entering into agreements with the court also allows it to consider the views and best interests of the sentenced person themselves, whether it be family links or cultural background, which, while they may not be paramount, are an obligation on the court when designating an enforcement state. For those states who are willing, but are concerned that they do not yet meet the required minimum international standards of imprisonment, it must not be overlooked that the court is ready to assist. In this regard, it is helpful to recall that in 2014, the court concluded a Memorandum of Understanding with the United Nations Office on Drugs and Crime. The UNODC will develop and implement, upon request, training and technical assistance programmes for national prison administrations on matters related to the enforcement of sentences of imprisonment pronounced by the court and on the application of international standards and norms governing the treatment of prisoners. We would encourage states parties to make use of this arrangement. And of course, no state is obligated to take a prisoner once an agreement is concluded. The double consent rule means that the state must explicitly consent to enforce the sentence of each prisoner that the court asks it to take. We welcome the news that Spain is entering into a sentence enforcement agreement with the court, but currently there are only 11 other states with sentence enforcement agreements with the court, which represents less than 10% of states parties. Only one of these states is in the Americas and one in Africa. We join with the court in asking more states to come forward, and we stand ready to assist and advise any state that wishes to enter into an agreement with the court and to share our own experience of doing so. I thank you.
Merci beaucoup.
Thank you very much. Having heard these two speakers who had requested to be on the speakers list beforehand, but we have some subsequent requests from the Secretariat. I see that we have 8 requests for the floor. And as I said a few moments ago, we also have the signing ceremony before we move on to the second segment of this morning's work. So we do have a time pressure that we have to contend with. So I'm turning to those delegations who've asked to speak, and please let me kindly request of you to limit your speaking time to just 1 minute, 2 minutes tops, please. I know that it's very, very brief and it's a real constraint, but that's the only way that we will be able to enable the second segment to start on time. So thank you very much in advance for your understanding. And let me begin by giving the floor then to the representative of Japan. Mr. Naganuma, you have the floor, sir.
Thank you, Ambassador Alapun. Let me begin by expressing Japan's gratitude to the co-facilitators for your initiatives and facilitation through the Hague Working Group and this plenary session on the topic of cooperation. While very fruitful discussions are underway with a focus on voluntary agreements, in order to promote cooperation between the ICC and state parties, it is also essential to enhance the capacity of each state party, including developing countries within criminal justice system. Today, aspiring to encourage cooperation set forth in the Roma Statute, with your permission, I would like to briefly explain initiatives of a United Nations institution for capacity building in this regard. The institution's name is United Nations Asia and Far East Institute for the Prevention of Crime and the Treatment of Offenders, very long name, and this is called UNAFE. UNAFE is a regional training institute of the United Nations established in Tokyo in 1962. It offers training programs for enhancing criminal justice systems in developing countries, with all costs and personnel covered by the government of Japan. To date, more than 6,000 practitioners from 142 countries and regions, including Asia, Africa, and Latin America, have participated in these UNAFE training programs. UNAFE training programs addresses matters related to the ICC. For example, at the program arranged in November this year, 2 officials from the ICC were invited to give lectures on the court and on financial investigations. Besides this, in January next year, the UNAFE director is scheduled to visit the ICC and give lectures to the staff of the court on judicial assistance and criminal justice system of various countries. And during President Hofmannsky's visit to Japan in October, the agreement between the ICC and UNAFE on cooperation was signed. UNAFE will continue to join forces with the ICC, and the government of Japan will work to generate synergy between discussion at the ICC, including those on voluntary agreements, and the activities of UNAFE, thereby facilitating partnership between the ICC and UNAFE and enhancing cooperation set forth in the Roma Statute. Thank you.
Merci beaucoup, Monsieur le Directeur. Et je...
Thank you very much. Thank you very much for making the effort to be as concise as possible. And in fact, I would extend that invitation to other speakers as well. If you don't have all the time to read out any written statements you've prepared in advance, you can just give us an oral summary and post that written document on the website. I now give the floor to the representative of Chile. Ambassador, you have the floor. Madam President, members of the Bureau, it's Chile's understanding that the establishment of the court was a long-sought objective of the International Committee and, in fact, was a way of giving more robust legal structure to the international community itself. Now, Chile believes that it's up to states parties to uphold their own statute in order to support the autonomy, independence of the court. This is essential for its work. In fact, the court plays a critical role not only for its fight against the impunity for the most heinous crimes, but also because of the fact that it acts as a deterrent and prevents future such conduct. Now, without prejudice to the foregoing, it's important to bear in mind the fact that states parties have a key role to play in prosecuting these crimes. This is one of the basic principles of the Rome Statute. And it's not just a question of admissibility, but it's also a guiding principle of the relationship between ICC and national jurisdictions. And for Chile, complementarity means the states parties' right and obligation to prosecute within their own legal frameworks the crimes that are set forth in the Rome Statute and to impose punishment and put an end to impunity. So there's this duality between the principle of complementarity and the practice of states. This is the best way to get effective complementarity between the ICC on the one hand and the states parties. The primacy of states in investigations and prosecutions of these crimes are also pursuing the objective of fighting actively against impunity. As a result, cooperation is required between the states and the investigations of the ICC. In fact, it's a critical factor to achieve the ultimate objective of the Rome Statute, which is to see that justice is done. Let me just say that cooperation also guarantees that those who are guilty of these crimes or their accomplices in attacks against the civilian population will be held to account. That's why it's necessary to build bridges between the ICC and the states involved in these situations. This is the only way that an investigation at that level can actually succeed. Our country, through its commitment to the court, is currently working on draft legislation for an agreement on cooperation between the Chilean state and the ICC. The purpose of this is to facilitate cooperation that we will be engaged in with the court pursuant to the statute. In fact, our country has always cooperated every time that we've been requested to do so. Madam President, members of the Bureau, the success of the ICC shall be determined by the level of cooperation it receives from the states. We encourage other states to sign cooperation agreements with the ICC and to bring their national legislation in line with the Rome Statute and the crimes that are defined therein. And lastly, I would like to express my country's support for Ecuador's initiative to convene a high-level seminar for the Americas with the ICC in June 2023. This will help us commemorate the 25th anniversary of the adoption of the Rome Statute. The purpose of this is to strengthen international criminal justice system through dialogue, the exchange of best practices on the principles of universality, complementarity, and cooperation throughout the Americas, with a specific focus on the Trust Fund for Victims. Thank you very much.
Je vous remercie, Madame.
Thank you, Madam Ambassador. And I now recognize the representative of Mexico. You have the floor. And thank you also for being as brief as possible. Thank you very much, co-facilitator. I'm going to follow your advice, and I will leave out some parts of my text, and I hope the interpreters don't get lost. Madam President, officials, delegates, cooperation and assistance amongst states parties, other states, and international organizations are essential for the ICC to fulfill its mandate and put an end to the impunity of authors who have committed the most heinous crimes against humanity. But moreover than that, it's important to provide assistance and protection to the communities that have been affected by these crimes. In this connection, Mexico would urge all states to continue doing everything they can to make sure that the 50 outstanding arrest warrants issued by the court can be enforced. We would also call on those states parties who haven't not done so to domesticate the principles of the Rome Statute to make it possible for us to cooperate and enact requests from the ICC, including those that are related to financial investigations, seizure, freezing of assets, the enforcement of arrest warrants, and requests for documents. Another key element of cooperation is where we can spread awareness about the ICC and do everything we can to ensure universal ratification of the Rome Statute and its full implementation within all our national borders. We could take advantage of the 25th anniversary commemorations to put a finer point on this. We are grateful to Ecuador for having extended this invitation in June 2023 for the entire American hemisphere to focus on the court and how we can better serve its objectives. To conclude, Mexico would like to reiterate its commitment to international criminal justice. We stress that the Rome Statute system is a complementary jurisdiction, and this can help member states and states parties to bolster their own national capacity for investigating and prosecuting the crimes that are defined in the statute. And it's in this connection that at this assembly and states parties, we can continue creating areas where there are greater opportunities for cooperation, either between national or international bodies, as well as through cooperation with UN agencies and with civil society. And we can leave the judicial work to the ICC. I would be remiss, Sir Ambassador, if I did not join you in thanking the Registrar of the Court, Peter Lewis. We're going to miss him dearly. Thank you very much, Ambassador. And I'm grateful to you as well, in particular, for having pared down your written statement, and we will, of course, have access to the full text later on. It's my pleasure to give the floor now to the representative of Argentina. Ambassador, you have the floor.
Bonjour, monsieur.
Good morning, Ambassador. It's a pleasure to see you in the chair of our discussions. Madam President, distinguished members of the court, colleagues, ladies and gentlemen, I would like to thank the co-facilitators for the cooperation, and France and Senegal for all of the work that they put into the past year, and for the preparation of this very important session on cooperation. Now, we know that the effective working of the court depends to a large extent on the amount of assistance and cooperation it receives, not just from states, from non-state organizations, but also international organizations and CSOs. The procedures of the court, nonetheless, are being delayed. This reduces the effectiveness of the court and increases its cost. Or we actually drop everything, and that would undermine the mandate of the court and the entire Rome Statute system. Now, to facilitate cooperation, the court has signed voluntary agreements with a limited number of countries. These agreements have been useful to increase legal certainty, not just for states parties, but also for the court itself. However, we need more support, much more support, and also to make sure that the workload of participation is shared evenly among the states parties. Let me just say that Argentina is the only country that has signed the complete four cooperation agreements with ICC on early release, enforcement of sentences, etc. And this stands as testimony to Argentina's full support for international criminal justice, with the ICC at its center in our fight against impunity. However, the practice of the court has demonstrated that even with these types of framework agreements that make it easier to cooperate with states, an only small number of countries have requested, or actually satisfied requests for cooperation. And this is why it's necessary for us to focus more on cases of a failure to cooperate and make sure that there is full implementation of all of the obligations that fall to states parties within the Rome Statute system. Now, these voluntary cooperation agreements make it possible for us to exchange best practices, past practice, past experience, both ways. And we welcome Ecuador's initiative in this connection to organize a high-level seminar for the Americas in June 2023, along with the ICC. And this will broaden and deepen our mutual understanding when it comes to the court's operational procedures and also its inner organization and the legal system that prevails in every state party. Signing these agreements is a concrete proof of any state's party's commitment to the court, and this is why I would encourage other states to sign voluntary agreements for cooperation with the court. Thank you very much.
Muchas gracias.
Thank you very much. Now I should like to hand the floor to the representative of the Netherlands. I just want to say that we have 5 speakers yet to go for this segment before we move to the signing of the agreement. So I just want to call on everyone to please be brief. Now I should like to hand over to Mr. Epile from the Netherlands. You have the floor, sir.
There it is. Thank you, Ambassador, for the floor, and I'll try to keep it brief. The Netherlands would like to thank the co-facilitators for their continued efforts on this important issue. As the host state, cooperation plays a key role in our day-to-day work. The court relies on our cooperation in many areas, ranging from the security and protection of the court's premises, officials, and witnesses, to the transport of suspects. We take pride in this work, as it allows the court to fulfill its important mandate. However, the court relies on the cooperation of all states parties. For the relocation of witnesses, the enforcement of sentences, and the release of persons, either on an interim or permanent basis, the court depends on voluntary cooperation. Unfortunately, far too often we see that voluntary cooperation is extremely difficult to secure for the court, making that suboptimal and temporary solutions have to be found. All the time, effort, and resources the court has to put into finding these solutions cannot be used elsewhere. The last few days, a lot has been said about the court's budget. The Netherlands finds it important that the court has sufficient budget to fulfill its mandate, but also that the court can use these means in an effective and efficient way. Costs related to the lack of voluntary cooperation are unnecessary if all states parties take on this joint responsibility. Voluntary cooperation agreements provide a general framework that allows states considerable flexibility to grant or refuse cooperation in a specific case. If more states conclude these agreements, this also means that the court does not have to over-ask those states that have concluded these agreements. The Netherlands hopes that cooperation with the court will continue to improve, and there are concrete steps being taken that make us hopeful. 2 days ago, the registry, together with Argentina, Sweden, and the United States, organized an important side event on witness relocation, which was very well attended. Last week, the Czech Republic signed a cooperation agreement on the protection of witnesses, and today, Spain will sign a cooperation agreement on the enforcement of sentences. We would like to commend these states for their efforts in allowing the court to fulfill its mandate and call on all states parties to follow in these footsteps. Thank you.
Je vous remercie. Je donne la parole.
Thank you very much. Now I should like to hand over to the representative of Belgium. Mr. Ambassador, you have the floor. Thank you very much, Mr. Ambassador. Thank you very much to the two co-facilitators. Thank you, Madam President. Thank you for giving us the floor. And since I'm not really very good at speaking briefly, I shall do my best nonetheless. And here we go. First of all, I should like to thank the principals of the court who laid out very, very clearly that cooperation is a responsibility shared among all states parties, and that it's vital if the court is to reach its objectives. And as stated under the Rome Statute, and as has been mentioned by many of the previous speakers, Belgium just wanted to take this occasion to recall exactly how important it is to have tailored measures so as to establish a framework for cooperation with the court, and how important it is to sign voluntary cooperation agreements. Firstly, we have in Belgium a central authority for cooperation, which means that we can have a dynamic dialogue with the court and facilitates our cooperation mechanisms. Also, we adopted in Belgium in 2004 a specific law on how to deal with requests for cooperation. And this law actually covers the different obligatory cooperation areas and also voluntary areas of cooperation, such as air transport for detainees, victim and witness protection, also the freezing and searching of assets and legal aid. Thirdly, states have the possibility of having cooperation agreements with the court and its very different and its various different organs. And Belgium has actually signed agreements with the court when it comes to cooperation with the OTP concerning sentence enforcement, provisional release, witness relocation, as was just mentioned, which is a question that we'll be discussing today, actually, and finally with air transport. The signing of these agreements enables us to settle upstream a lot of the practical modalities for how our cooperation will roll out. And it's also important to remember that such agreements don't actually bring about any new obligation to cooperate. The specific requests that come under voluntary cooperation are actually examined on a case-by-case basis in Belgium in virtue of the agreements that we've signed with the court. And I just wanted to end by saying that the framework for cooperation that we have in Belgium that I've just outlined for you actually enables our Belgian Central Authority to deal every year with the growing number of requests for cooperation more efficiently. And we get requests for cooperation not only from the ICC, but also from international jurisdictions and mechanisms and teams under the UN. And I just wanted to thank you and pay tribute to Peter Lewis, the outgoing registrar Registrar for all of his outstanding work over these last 5 years. Thank you.
Merci beaucoup. Et je donne...
Thank you very much. Now I should like to hand over to the representative of Bolivia. You have the floor.
Bonjour, buenos días.
Good morning. Madam President of the ASP, Mr. Prosecutor, on behalf of Bolivia, I just wanted to send our warmest greetings to the principals of the court and on behalf of our president, we wanted to underscore the important work underdone by the court. The plurinational state of Bolivia would, as a signatory to the Rome Statute, ratified in 2002, want to reiterate its commitment to complementarity and cooperation with the POC. We know that these are so important for the court's work under the Rome Statute, and given the advances made by the court when it comes to enhancing cooperation, we're always looking for spaces in which to foster greater dialogue, in which civil society and states parties can be in a dynamic dialogue with the court in the name of solidarity through protection and relocation of witnesses. In particular, it enables the court to fulfill its main mandate and keep hitting these milestones. As a state party, Bolivia is also working on its internal legislation, and the regulations are discussed at various levels and since many and as broadly as possible, so that we have a solid base for prevention and for the processing of any cases of international crime that come before us, and we encourage the court to doing more. Now, bearing in mind that the international community is facing difficulty ensuring equitable geographical representation and in ensuring gender balance, multilingualism, and the representation of various legal systems, we encourage the court to do more to ensure the universalization. Bolivia commends the court for all of the initiatives that are being done in our region of the world, the Latin American agreements, such as, for example, the upcoming seminar in Ecuador next year. We just wanted to end by underscoring how important complementarity is, which is one of the very bases upon which we can stand firmly in our fight against impunity, and we call on all states parties to keep promoting this pillar of the court's work. Thank you very much.
Merci beaucoup.
Thank you very much, madam. Now I should like to hand over to the representative of Ecuador.
Muchas gracias.
Thank you very much, Mr. Co-Facilitator. Dear co-facilitators, Madam President, principals of the court, I just wanted to, first of all, express our congratulations to the co-facilitators, the ambassadors of France and Senegal, for the outstanding work that they have done in this context on the issue of cooperation. Ecuador believes that this is one of the key pillars for strengthening the efficacy and effectiveness of the court, and we urge all states parties to increase their cooperation with us so as to ensure its smooth operations under the Rome Statute system, and particularly when it comes to executing arrest warrants. And we also wanted to take this opportunity to reiterate Ecuador's commitment to holding the high-level seminar for the Americas and the ICC in June 2023, and this will coincide with the 25th anniversary of the adoption of the Rome Statute, and in this way it will further strengthen the international legal system based on the principles of complementarity, universality, and cooperation in the Americas, with a special component dedicated to victims. We're looking forward to that event. We wanted to express to Chile, Mexico, Argentina, and Bolivia, and others our thanks for their support in organizing this high-level seminar in Ecuador. This high-level event for the Americas is going to be an important opportunity to further bolster the Rome Statute system and strengthen this particular pillar of its work, which is cooperation. Thank you.
Je vous remercie.
Thank you very much. Thank you very much, Mr. Ambassador. Now, it is 12:45. We've still got the signing ceremony to do before we even get into the second subject. So we really are running out of time. So unfortunately, I am obliged now to give the floor to our final speaker, which is from the representative of Uganda. I'm going to ask you to be extremely brief. And for any other delegations who would have liked to have taken the floor, and I do understand, and we're delighted to see that everybody is so keen to participate in this rich discussion, I will be inviting those delegations to kindly submit their texts, and we will have that duly reflected. And we really do apologize that we cannot take any more time to give the floor to everyone who wanted to take the floor. So now the representative of Uganda, and I'm going to ask you please to be as brief as you can. Thank you.
Thank you very much, co-facilitators. We'd like to commend you for the work that you have done on these important aspects of implementing the court's mandate. Uganda welcomes the appreciation expressed by the court's principles for the cooperation that states parties have rendered to the court. From our experience, we would like to emphasize that cooperation is not only limited to monetary considerations, but quite often, cooperation takes several forms, as emphasized by the deputy prosecutor and the registrar. Indeed, specific cooperation agreements for particular tasks such as witness relocation are essential, and our experience shows that all these aspects can be managed where a general cooperation agreement exists. We would therefore like to encourage states parties to enter into cooperation agreements within which all aspects of assistance can be rendered, and thus enable the court to be in a better position to carry out its mandate. I thank you.
Merci beaucoup.
Thank you very much. Now, as I was saying a moment ago, I should like to invite all of the other delegations who would have liked to have taken the floor in this discussion to kindly forward the text of their statement to the Secretariat so that we can duly take note of it in that way. Now, as I did announce, we are going to move on to the signing ceremony for the cooperation agreement between the court and the Kingdom of Spain. And so I should like now to hand over, I think, to Madame President of the ASB to preside over the proceedings. Thank you. Thank you very much, Ambassador. And it is a huge pleasure and a privilege to be able to preside over this signing of this voluntary agreement on sentence enforcement between the Kingdom of Spain and the International Criminal Court, organized by the co-facilitators, France and Senegal. So just responding to your call to be brief, I shall just take this moment to say that we want to thank and congratulate Spain most sincerely for signing this important agreement. And I wanted to take this occasion also to launch a call to all other states parties to encourage them to sign similar agreements. And now I would like to invite the President of the Court, Judge Piotr Hofmansky, and the Ambassador of Spain to the Netherlands, Her Excellency Consuelo Femenia Guardiola, to kindly come up onto the stage in order to sign this agreement. Thank you. Now I wanted to give the floor to the Ambassador of Spain to the Netherlands, Her Excellency Consuelo Ferminia Guardiola. You have the floor. Microphone, please. Madam President of the Assembly, Mr. President Judge Hofmansky, co-facilitators, Deputy Prosecutor, Registrar, Excellencies, ladies and gentlemen, it's an honor to have been able to have signed this agreement on sentence enforcement here today with the ICC on behalf of the Kingdom of Spain. A lot of the people who took the floor before me today, all in this session on cooperation, I think raised some of the key issues. But I just wanted to reiterate that Spain is joining this network of voluntary cooperation agreements because we feel that they are of vital importance, both in terms of practical issues to enable the court to fulfill its mandate. And this includes the final link or the very final links of sentence enforcement as part of the legal process. Now, Spain is firmly committed to the fight against impunity, and it's a commitment that we made 25 years ago with the Rome Statute, which is currently being embodied with the signing of this very relevant and important agreement. As other countries have already done, we wanted to thank the co-facilitators, and we also wanted to extend our thanks to the President of the Court and to encourage other countries to follow suit and give these practical indications to our long-standing agreements with the Court. Thank you very much for organizing this ceremony today, and thank you to one and all. My thanks to the Ambassador of Spain for that statement. And now I should like to hand over to the President of the International Criminal Court, Judge Piotr Hofmansky. The floor is yours.
Ambassador Ferminia, Excellencies, ladies and gentlemen, I am very pleased that today we have the opportunity to sign an agreement and an enforcement of sentences between the International Criminal Court and the Kingdom of Spain. I share with you our profound appreciation for Spain taking this step in its relationship with the court. As the court's caseload increases, so does the need for voluntary cooperation in the form of enforcement sentences of imprisonment. The court is grateful that Spain today joins the small but growing group of engaged state parties which have declared their general willingness to assist the court in this regard. In signing this agreement today, the Kingdom of Spain demonstrates its steadfast support and commitment to ensuring the proper functioning of the court. It is enshrined in the Rome Statute that state parties should share the responsibility for enforcing sentences of imprisonment pronounced by the court. With this signature, Spain has assumed this responsibility. I sincerely hope that other states, parties from all regions of the world will follow Spain's example. When state parties all play their part in assigning the court's operations, the effectiveness of the ICC system as a whole is enhanced. Once more, on behalf of the International Criminal Court, I wish to express my sincere gratitude to you, Excellency, and the Kingdom of Spain for extending this important measure of support to our joint institution. Thank you very much.
Muchas gracias.
Thank you very much, President Hofmansky, for that statement. I should like to thank the Kingdom of Spain yet again for having signing this agreement and this initiative, and I encourage everybody to applaud this initiative.
Y con esto.
And now I should like to hand back to our moderators so that they can move on with the upcoming segment on witness protection. Over to you. Thank you very, very much, Madam President of the Assembly. Yes, it's time for us to close this first segment. I wanted to offer my warmest thanks to all of the representatives of the court for their presence, for their statements, and I'll invite them to leave the podium. Thank you again for all of your input into this first segment. Thank you.